Well, Section 221 is the part which Justice Inyang Ekwo has relied upon to sack the governor of Ebonyi, his deputy, and 17 lawmakers who defected to the platform of the All Progressives Congress from the PDP. The bone of contention is who owns the votes garnered by any political party in an election, and can it be transferred to another political party upon defection? These are some of the questions which we are going to be posing to our lawyers this morning. We have with us in our studios Mr. Paul Ogbole, who is a senior advocate of Nigeria. Sir, you're welcome to Sunrise Daily this morning.
Thank you very much.
And joining us via Zoom is a senior advocate of Nigeria as well, Mr. Kunle Adegoke, who is going to be joining us via Zoom from Oshogbo. Mr. Adegoke, you're welcome to the program as well.
Thank you very much. Good morning.
Just to also add that Mr. Adegoke is a chieftain of the All Progressives Congress. So let me ask you, Mr. Ogbole, who's here with me in our studios, what you made of that, because according to my colleagues who covered that case in court, they said nothing in the court gave away the sort of judgment that was going to come, shall I say, from the gavel of the judge yesterday. Did it come to you as a surprise?
Well, thank you very much. In most cases, when cases are before the courts of law, you cannot really for sure predict where it will go. So I think this is one of such cases where it was difficult to predict the direction the judgment was going to go. And I would also say that the position of the law regarding defection of candidates, particularly in the executive, is not entirely very settled. So it could have gone either way. Because I'm also aware that in the Gusau case, also the Federal High Court, the decision went the other way. In other words, the court declined to declare as nullity the camping of Matawale and the other gentlemen who were with him from PDP to APC. So here we have a situation whereby what has happened is that the court this time around, of course of coordinate jurisdiction, has pronounced its judgment that the position of the law, relying largely on Section 221 of the Constitution, is that votes are canvassed for the party, in this case PDP. And the governor came on board on the strength of the votes for the party. And he cannot take those votes that brought him on board to another party. The votes still remain with the party. And so that's the position of the law as it is as at now. Because where there are conflicting judgments like that, the latest in time would be the position of the law until set aside by an appellate court.
So we'll come to that much later in terms of what should happen, because the governor of, like I said, the embattled governor now of Ebonyi State gave a press conference, and he made reference to how an affidavit was sworn and how, they tried to let the Federal High Court know that, there were other cases subsisting. In fact, that particular matter had already been handled by, I think, a state high court, etc., etc. We will listen to that track shortly. But what I first of all want us to do is just set to look at the case on its merit in terms of, whether there was anything there in the very first instance. Because some people argue, you just said it's not a settled matter in law. Apart from this issue of defection, are there other cases which also, give credence to the fact that political parties own this vote? Some people would refer to Kogi, what happened in Kogi, and perhaps Supreme Court judgment, even though we've been told that that was a one-off. I don't know how that works. What happened in Rivers when...
The Amechi case.
Exactly, the Amechi case. So do these also lend credence to the judgment which Justice Inyang Ekwo gave yesterday?
Well, I think the authority upon which this judgment is based is largely Section 221 of the Constitution, which talks about votes belonging to the party. Relating it also with the case of Amechi, if you recall, Omehia became the candidate when Amechi was, I think, either disqualified or removed as candidate at some point in time. But at the end of the day, Omechi won the election, and the court declared that these votes were for Amechi, who...
Omehia won the election, yeah.
He won the election, and then the votes were declared to have been for Amechi because he was the validly nominated candidate of the party, resting this argument on Section 221 of the Constitution. Now, in the case of... I'm aware that there's an attempt at the Electoral Act Amendment of 2020, Section 141, if I recall exactly, that talks about, participating in the entire processes of the case of the election to give you the vias to challenge and also to qualify to be a candidate. But that is the act, not the Constitution. And generally, the Constitution is superior to the act. Now there's an amendment to the act, which is, there's already an amendment to the act, the 2022 Act, and there's also an attempt at a further amendment. So some of these things they're not totally settled. I believe in the days ahead we will know, because the National Assembly is still, the issue of the amendment to the amended Electoral Act is before them, and I'm aware that the court already has stated that there should be a stay, an interim order of court that parties should maintain some status quo ante bellum, so that pending the hearing of the motion or notice, which is still pending, so I wouldn't want to go into that. But basically, the strength of the judgment, it derives its strength largely from the provisions of the section of the Constitution, the Amechi case, the case against Bello, that's a Falake case of Bello in Kogi State. These are strong wickets upon which that judgment is rested upon. And
that's just the judgment.
The judgment of yesterday, yes, okay. Of Justice Eko.
Let me bring.
But I would admit that all we see for now are snippets in the media. So a fuller understanding of it will be when the judgment is made available, the proper judgment is made available, and when you glean through it properly, you will have a better positioning of the matter.
Well, I would like to read out Section 221 for our viewers. It says, no association, and it's a section that talks about political parties. It says, no association other than a political party shall canvass for votes for any candidate at any election or contribute to the funds of any political party or to the election expenses of any candidate at an election. That's what Section 221 of the Constitution says. So let me take this to our guest in Oshogo. I'd like to ask you, is this a rather broad interpretation? Because it doesn't say anything about defection. Is this a rather broad interpretation of this particular section of the Constitution?
Thank you very much. I have considered the provision of the Constitution in issue, and one will realize that the mode of interpretation of the Constitution must be one that will take into consideration a holistic approach and not an individual consideration of a particular provision of the Constitution. The interpretation by the courts with respect to votes being only capable of being canvassed by a political party is not talking about a situation other than canvassing for votes from the general populace. And to that extent, it is basically saying that an association that is not registered as a political party cannot canvass for votes from the populace. The implication here is that it's only a political party that can print manifestos, go to the people, and call upon them to vote for not that political party simpliciter, but for the candidates of the political party on which platform the candidate is running. Any other interpretation that will go beyond this, except in such circumstances recognized by the Constitution itself, will be out of the way. Equally, any other interpretation that will not be in accordance with certain decisions that the court has recognized may not be consistent with what the contemplation of the Constitution is in this instance. To a large extent, I believe that the interpretation placed on Section 221 by the Federal High Court is not consistent with the intent of the draftsman of the Constitution in this instance.
There are a few key questions, sir. I'd like to first of all ask you whether or not, that also applies to the lawmakers. Because some people, I think they say that the Constitution is clear in that respect with regards to what should happen to lawmakers who defect from political parties, except in the situation where there is a division. And some people have extended it to say at the national level of their political parties. So the governor, his deputy, and lawmakers, 17 of them were sacked from office by this judgment. Would you say that the judge was correct in the judgment, at least which applies to the lawmakers, which is clear enough?
We need to look at the judgment critically. However, where the requirement of the Constitution is met with respect to the lawmakers, the decision of the Federal High Court may be correct. However, where the decision is not consistent with what the Constitution has stipulated with respect to circumstances in which a defecting member of the Parliament can vacate his seat, then that decision will not be correct. Let me explain further on this. If you look at Section 66, 1G of the Constitution, which pertains to the National Assembly members, and Section 109, 1G, Section 1G of the same Constitution relating to House of Assembly members, it provides that a condition, a situation where a member of the House of Assembly will vacate his seat is where he defects from the political party on which platform he was elected to another political party. However, there is a proviso to this, provided that there isn't a division in the party that he defected from. And such division in the party has been interpreted by the Supreme Court in Abegunde and Ondo State House of Assembly to be such division that will be national in character, and not that maybe there is a division at the ward level or at the local government level, and not even at the state level. That the party is divided in its leadership at the state level would not be a justification for a member of the Parliament in the House of Assembly or National Assembly to defect from the party on which he was elected. Where there is a division at the national level, then the Constitution recognizes such a situation as allowing a member to defect from the political party. Or equally, where that party, where he was elected, merges with another political party duly recognized and registered by INEC, then it cannot be a grant for him to vacate his seat as well. In this instance, insofar as the lawmakers defected to APC, once it is established that there is a division at the national level of PDP that would justify such a defection, then they are good to go. Once there is no such division at the national level, then the decision of the Federal High Court will be faulted. My status as a member and chieftain of APC notwithstanding, I must give a correct interpretation as laid down by the law. And that is why I feel that there is much more trouble for the House of Assembly members and a greater stake for them to surmount than the governor and the deputy governor. With respect to the provision of the Constitution relating to the president, vice president, governor, and deputy governor, there is no such provision that the president or vice president or governor or deputy governor shall vacate his seat if he defects from one political party to another. And these have been settled by the Supreme Court in AG Federation, Attorney General of the Federation, and Atiku Abubakar. That is a decision, the grains of which there hasn't been a contrary pronouncement by the Supreme Court. If we recall, Atiku Abubakar had a problem with his president, Olusegun Obasanjo, and it became so deep that he felt he had no future in PDP. He defected to Action Congress Party. And upon his defection, the Attorney General brought an action challenging his status as Vice President of Nigeria. The Supreme Court categorically pronounced that yes, if it were to be a member of the legislature, National Assembly, or State House of Assembly, then it would be too bad for such a person. He will have to vacate his seat. But for governor, for president or vice president, there is no such provision in the Constitution. And whatever is not forbidden by the Constitution cannot be interpreted by the court to be an anomaly. Although the court took cognizance of the fact that, yes, it might be very bad, it might be distasteful that a person elected on the platform of a party as president or vice president and a fortiori as governor or deputy governor, defecting from the party on which he was elected to another might be quite very sad and immoral. But the law here, the Constitution here, is not ruling on the immorality or morality of the situation. It is talking about the legality or otherwise of the situation. So the Constitution having pronounced with respect to the legislature, with respect to the National Assembly and the House of Assembly, that one is settled. However, with respect to president, vice president, governor, and deputy governor, there is no such provision that he shall vacate his seat. The only condition, the only thing that may make such a governor or deputy governor to validly be removed is where the House of Assembly considers such an act to be gross misconduct, because the definition of gross misconduct by the Constitution is left to the discretion of the legislature, the National Assembly, or the House of Assembly to consider whether defection from the platform on which he was elected to another will be sufficient gross misconduct as to warrant his removal from office. It is only the Assembly, the national hostage, that can decide whether to effect that provision and remove such governor or deputy governor. In this instance, the court lacks the power.
Okay, Mr. Adegoke, if I may come in, I'd just like to ask you, you've talked about how Section 221, I don't know if you can hear me, how Section 221 only talks about political parties canvassing for votes. But you haven't quite spoken to who owns the votes that the political parties canvass for. Is it the political parties themselves or the candidates for whom they canvass the votes?
Yes, interpretation in this regard is divided, and it depends on the circumstances in which the ownership of the votes is being considered. When you look at cases like Falike and INEC, in which I effectively participated as counsel, it was our argument that votes cast belonged to the political party in this particular instance. An election was held, and in the middle of the election, our governorship candidates died. And the question now is that, will such be a situation to say that the votes can be considered as not belonging to anybody? And we can pass the position that, yes, where the governorship candidate dies in the middle of the election, the provision of the Constitution does not say that automatically the deputy governorship candidate shall step into his shoes, on the basis of the fact that, yes, votes belong to the political parties, who in the political party can take the benefit of such votes that are left behind by the governorship candidate that died in the middle of the election. Were he to be after the conclusion and pronouncement of the election, the votes will equally still belong to the political parties that the vice president or deputy governorship candidate can step into. In this regard, we look at the provision, who can take the benefits of this? And we came to the conclusion, which the Supreme Court effectively agreed with, to the effect that it is only a person who participated in all the stages of the electoral process of that particular election that can take benefit of that. A deputy governorship candidate was chosen by his governorship candidate after the primary had been concluded. And once this is the position as pronounced by the Supreme Court, that is the position of the law as of today. However, in situations where, for instance, in Amechi and INEC, where the Supreme Court pronounced that the votes belong to the political party, and on that basis, PDP Amechi could inherit the benefit of that particular election and be sworn in as governor. That was prior, because the Constitution does not provide for all the gamut to the process of an election into a particular office. It left a lot of duties to the National Assembly to perform by enacting relevant acts that will govern such electoral process. So once the Supreme Court pronounced that, the National Assembly exploited the provision of the Constitution that gave them the powers to enact laws, and thereby enacted Section 141 of the 2010 Electoral Act, stipulating that if you did not participate in all the process, in all the stages of the election, you can be sworn in as the winner of that particular election. And that is good to that particular extent. Each case must be utilized, must be interpreted based on the circumstances in which it was pronounced. Now, let us look at the case of CPC and Ombugadu. In that case, the Supreme Court was quite categorical that yes, votes will belong to the political parties.
Okay, I'll have to interrupt you, I'm afraid. I'd like to also get the thoughts of Mr. Wole on that, whether or not he agrees with you. Do you agree with him?
I agree with him on his exposition on the judgments of Faleke, as well as Amechi, and then the provisions of Section 221. The Atiku case he cited came earlier in time than the Amechi case. So irrespective of the provisions or the pronouncements of the Supreme Court in the Atiku case, the Amechi case came, and the Supreme Court, the same Supreme Court, was of the view that the votes have votes for the party. And that was re-echoed again, gladly he participated in that case, in the Faleke case. So those two cases and the provisions of Section 221 of the Constitution, of course the Constitution overrides where there's a conflict, the Electoral Act. It is on the strength of these provisions that the judge, my Lord Justice Ekwo, had the vials and the strength to arrive at that judgment. And I still think that is a very, very good judgment. He
thinks it needs to be taken on a case-by-case basis, because even the Supreme Court, it would seem, has not been consistent in terms of the verdicts it has given in some of these cases.
Well, generally, there are precedents that, that govern subsequent cases. But, of course, those precedents must also be related to the line of the facts of the particular case. So, yes, cases would differ. So the peculiarities of a particular case will determine to what extent you can apply a precedent. So in this particular case, it is fairly novel. Like I said, the law is not entirely settled on this matter. It's not a silver bullet that you say it answers all questions. So the law is not entirely settled. And I do know that they will still proceed on appeal. The last is not heard of this matter. It will go all the way to the Supreme Court. And at that point in time, we can say, okay, look, this position of the law is settled. But as it stands today, I see it as a good judgment. And that is the judgment of the land as of today.
Let's take a break at this point. We'll be back shortly to discuss other matters, other issues surrounding this particular matter. Please stay with us.
I've listened to the judgment of Ekwo, and it's very obvious that he was on a mission. He was making all efforts to upturn the rulings of the Supreme Court and appeal courts on issues like this. We have had the rumors before now that he was determined to give judgment against all known laws and the Constitution, first to embarrass APC, two, to embarrass the federal government. For me, I do not feel worried, but I feel so sorry for the judiciary. The executives may have problems, the legislature may have problems, but the moment justice could be purchased, then we are in trouble in this country. And the ruling this afternoon is a clear evidence that this country is in trouble. And let me tell you that this same judge has over 10 cases against Ebonyi state government with him. And you can imagine what is going to rule. We have petitioned him to NJC, and we will follow it up at all costs to ensure that this man is brought to justice. I want you to disregard the judgment. It is null and void. There is a substituting judgment in Zamfara State, and there is also a judgment in Ebonyi State. So we've chosen the one to obey. We will not obey his ruling. We will obey the ruling of a competent court of equal level that says you cannot sue a governor.
Well, Governor Dave Ebonyi is speaking there in the aftermath of the judgment. Well, let me ask Mr. Adegoke, because the governor was quite categorical about the next line of action. But is it right for him to say, I want you to disregard the judgment, it is null and void, saying there's a subsisting judgment in Ebonyi and Zamfara State? And then he went on to say, we have chosen the one to obey, we will not obey this ruling. So I imagine he's referring to the one in the High Court in Ebonyi State, and this particular one, saying that the High Court, in the Ebonyi High Court, will be obeyed, and this one will not be obeyed. Is that right?
No, that cannot be a correct position of the law. We must realize that when a decision of a court is given, that is the decision as at that particular moment. However, it is the provision of the Constitution that there will be right of appeal. And equally, under the Court of Appeal Act, a party in this instance has 90 days within which to appeal the decision of the High Court. In the interim, the status quo will be maintained once the appeal is filed within that particular appeal. Also, this is something that relates to a public office. A situation where today we swear in the PDP candidate, and tomorrow the Court of Appeal nullifies the decision of the High Court, we swear in back the governor, who probably we can now say is former governor. Then it goes to the Supreme Court nullifies, then we now swear in again. So, I mean, the position of the law has been cleared on this, that in the interim until the determination, just like in election petition cases, the parties will await the determination of the appeal in that period. So okay. The position of the governor, to the extent that he is going on appeal and the PDP candidate cannot be sworn in yet, is quite correct. But distinguishing it that the one in a particular state be recognized for APC candidate to be sworn in, and here PDP candidate should not be sworn in, is like subjecting the law to indecent pronouncements. In the interim, however, he has to be in office until the determination of his appeal. If he doesn't appeal within 90 days, then the decision of the High Court is final.
So you're saying, as at now, that judgment of a court saying that, INEC should swear in another person, which the PDP has submitted, at least sent names already, you're saying that that does not hold water for now?
It cannot be immediately implemented. It is a decision, it is a valid decision at the moment, but cannot be immediately implemented.
Okay, let me ask Mr. Ogbole if he agrees with you on that, especially, clearly you think that you can't pick and choose when it comes to judgment, but in terms of the urgency of the judgments, the pronouncements, the orders that were given, Mr. Ogbole, do you agree that, that doesn't hold water for now until some sort of appeal and that decision is made?
Well, clearly, the governor of Ebonyi State has the right of appeal, which he must explore within 90 days. But it is important that until there is that appeal is filed, records are transmitted, and the appeal properly enters, that the judgment still remains valid, and the court, the lower court, will take cognizance of the fact that appeal has entered. And when appeal has entered, the lower court, of course, having delivered the judgment is functus official. But the important thing is that if appeal is not filed timeously, records transmitted, and appeal enters, you cannot be talking about a stay. You can't be talking about a stay. So the fact that there is a notice of appeal filed per se does not act as a stay. So that is very important. So it depends on the strength, on how fast they transmit their appeal, file their notice of appeal, and then go on. Otherwise, clearly, the judgment, like I said, remains valid, but the only step that can be taken is when they go on appeal. And the larger interest is when the Court of Appeal or the appellate court, grants a stay. However, the lower court will be conscious of the fact that once appeal has been transmitted, and INEC, of course, once appeal has been, records have been transmitted, notice of appeal filed, and appeal has entered, that it is only conscionable that parties maintain status quo. So that really is a position.
On the back of that judgment,
picking and choosing which judgment of court, with due respect, I think that is not appropriate. Clearly, there are conflicting judgments in Ebonyi, Zamfara, and the latest one being the judgment of Justice Ekwo of the Federal High Court, Abuja. Now that there's a current judgment of the Federal High Court, even though of coordinate jurisdiction here in Abuja, this is the latest of the judgments. For now, this latest judgment, we delivered yesterday, remains the position of the law, and it is instructive that parties see that as the position of the law and abide by it. So choosing to say the one that is favorable to you or the one that is not favorable to you will determine which law you will abide by with the greatest respect. I think that is not appropriate. Okay,
Mr. Ogbole, 2 points I'd like you to clear. One, on the back of that judgment, as at now, I mean, you said we're not quite clear on whether the appeal has been filed, whether it has been received, and all of that. Is Governor Umahi still the governor of Ebonyi State, as at now?
I'll admit that is a tricky question. Technically speaking, going by the judgment, you will say he's not the governor. But the reality is that there can't be a vacuum. If the governor goes and the deputy governor also goes, then INEC has not, we've been told that INEC has received names of the nominees from PDP. But if the reality is that if Umahi is not governor today and the deputy governor is not there, then it is a vacuum which is void, and nature abhors such vacuum. So I think practically speaking, you would say that, yes, Umahi is still governor. But technically speaking, unless that judgment is set aside, it still remains a law that he has been removed as governor.
So, I mean, technicality and practicality, very interesting terms there. But also, regarding the timeline, so the PDP went to court last year to challenge the governor's defection. And, I mean, time was given for judgment early in this year that it will be on March the 8th, which was yesterday. And then early this year, the state governor went to court, which is the one in Ebonyi State, to perhaps lodge the same case before a court in Ebonyi State, and a judgment was given, I think that was last month. So in terms of, the timeline and which one should we follow through with, as it were, what would you say, really? The one that was lodged last year, or the one that was lodged this year by the Ebonyi State government and judgment given, was that duplication of a case? Was that abuse of court processes? What do you think about that?
Well, first, it may not matter now which case was filed earlier, because from my reckoning, I think the case here was filed earlier, and then the one in Ebonyi was filed subsequent, but judgment entered in that one, then this judgment came. But the position is that now that we have this current judgment, it supersedes earlier judgments, whether they agree with it or they are at variance with this current judgment. That one is clear. The other aspect, sorry, may I get you again? The other aspect you talked about.
Where it's been said by some that may have been an abuse of court process because there were the same issues that were lodged at a different court. Do you agree with that?
Well, to say it is abuse of court process, the question is, at this point in time, which case was filed earlier when you're looking at the area of abuse of court process? Then the question again is that who are the parties? Like in this particular case of the Justice Ekwo's judgment, I recall the governor himself, the deputy governor, and 15 members of the House of Assembly. And then the specific reliefs sought. Now, you must relate that exactly with the case of the case that was filed in Ebonyi. So I wouldn't know those facts now, but for abuse of process to tenure to occur, you must see that there's a correlation, a replication of the parties, subject matter, reliefs, and all of that. They will come in and then you now begin to look at the issue of abuse of process. But where there's an abuse of process, the legal mechanism itself has a way of addressing that. I listened to Governor Umahi talk about petitioning to the NJC and and things like that. Well, it's a right of anybody to file a petition against. But the appropriate thing is actually file your appeal. Okay. If you are in disagreement with the judgment of court, file an appeal, and then you go through the entire legal process all the way to the Supreme Court.
Okay.
So if at every judgment, if you are dissatisfied with every judgment, and the first thing to do is to cast aspersion on the judge and the judiciary, and so what the man who is, suppose you are victorious at the Court of Appeal, then you begin to praise the Court of Appeal. And then if you are not victorious at the Supreme Court, you again begin to condemn the Supreme Court. I think what is important is let us just await the entire legal process.
Okay. Well, let me ask Mr. Adegoke this next question. Well, Markwe did say earlier, just before we took the break, that we'll look at other issues surrounding this particular judgment. And one of them is something that Governor Umahi mentioned, where he said that you cannot institute a case against a governor. Section 308 is clear on that, and the people that are involved. And the Constitution says no civil or criminal proceeding can be instituted against a governor, a deputy governor, president, or vice president. In this case, and as it stands, what kind of proceeding would you call this?
Right. The provision of the Constitution provides immunity for the president, vice president, governor, and deputy governor. And the immunity is to the extent that while in office, they cannot be sued in personal capacities. Now, the action in this particular regard was brought against the governor and the deputy governor for an act they did, which the petitioner, the plaintiff, PDP, felt was wrong. And on that basis, they were being sued not just as officers in power, as a nominal party, as recognized by Section 308 of the Constitution, but rather they were being sued in personal capacity. The immunity in this regard is being trampled upon by the plaintiff. And for the court to go in line with that, it means that the court was not cognizant of the decision of the Court of Appeal in Ejura and Idris. This is a case that originated in Kogi while Governor Idris was the governor. And the plaintiff in that case brought an action by originating summons for the removal of the governor. And the Court of Appeal was quite categorical about it. You cannot bring an action by originating summons to remove a governor. The Constitution is well spelled out on the conditions and circumstances when a governor can be removed from office. One of such is not when he defects from the party on which he was elected into another. So there is no basis for PDP in this instance to sue at the Federal High Court in Abuja to say remove the governor for defecting from our party to another because we are the owners of that of the votes that brought him into power. The Constitution does not recognize such a right of action. The only thing they could have done could be to proceed to the House of Assembly and challenge the defection of the governor and say that, look, remove this man. Where the House of Assembly is equally complicit of a similar thing and will not be a good judge in its own cause or a cause similar to its own misdeed, then what what PDP can do in that instance is to bring that action they brought against the House of Assembly members of Ebonyi. Now, if they are effectively removed and PDP members, as well, or an election is to be conducted, now won by PDP members, they will become they can move to impeach the governor and the deputy governor. There is a procedure for everything. So that is what the Constitution has provided. And when you look at it, the contention, which was what I was about saying, the contention that votes belong to the political parties will operate in different circumstances. Look at the decision of the Supreme Court in CPC and Ombugadu. The Supreme Court said, no, the political party is just a platform. It is a vessel. The votes will ultimately, who can be sworn in as winner? Not the political party. It is the candidate. The candidate ultimately owns the vote. Also, in 2018...
Well, Mr. Adegoke, while that argument that you're proffering is valid, I mean, I can't be working in one organization and when I'm leaving that organization, I have to completely leave that organization if I'm going to go to another organization altogether. All the benefits that accrue to me in the first organization, I have to abandon when I'm moving to another organization. If I don't know if that's valid in this particular case.
That argument is valid to the extent that it is not pertaining to a constitutional office of governor, deputy governor, president, or
which is the reason for which I asked that question. But let me ask you, Mr. Ogbole. Well, in your response to this same question, factor in the fact that the Constitution, the laws are not completely clear on the circumstances surrounding the defection of a governor or deputy governor and all of that. We'll come to whether it's governor or deputy governor defecting, in different political parties subsequently. But in your response to this same question of Section 308, factor in the fact that the Constitution is not clear on what happens if a governor defects to another political party while in office.
Well, I'd say that yes, the Constitution is not absolutely clear as it relates to governors and deputies. But it's clear as it relates to the parliament, the legislative, members of the respective houses and National Assembly. However, it has been argued that the principle of judgement generis, which is to say when there is a mention of A, B, and C, you can interpret D to be the next that follows. On the other side, it's also argued, and quite rightly so, that where there is no specific mention of an item, you do not also impute it into it, particularly when there's a mention of a particular item. Clearly in the Constitution, the procedure as the effect of defection on the part of the legislature, the effect is very clear. But for the executive, it is not crystal clear. And that is why in constitutional practice, where the courts again interpret the same constitution, which again is the ground norm, but the courts interpret it. And that was why you see that across the lines, the courts have tried to give life and meaning to several provisions of the Constitution. One of which we saw in the Amichi's case, interpreting Section 221. So where this is the case, again, it is either that the Constitution is amended to specifically provide for the effect of cross-carpeting or decamping by members of the executive, the governor and the deputy, the president and the vice president, or it's either it is very clear there, or the court again via adjudicatory process, all the way to the Court of Appeal and the Supreme Court, come out with a definitive pronouncement on a situation like what we have at hand currently. And then it will clearly rest the case.
Okay.
Because as many cases as you will find for, you probably could find a similar number against. Because, like I said, the law is not clearly settled on this position.
Okay, just to be clear, I earlier said that the judge ordered that the names be sent to INEC to be sworn in, but actually to be sent to INEC to conduct a fresh election, just to put that out there so we're clear, you know, on the position of the judge.
Well, just one last question from me for you both gentlemen. With both of you agreeing that the Constitution is not clear on certain things, and we have a Constitution review process going on, would you agree, Mr. Adegoke, that there should be an adjustment to that? Because there's been that clamor, you know, in the media as well, that the defection should be abolished altogether. So let me begin with you very quickly, Mr. Adegoke, before Mr. Obade responds. In 30 seconds, do you think defection should be made clear in the Constitution?
No, well, the point is, we must get something clear. The position of the law is clear. The provision that was interpreted in the case of Atiku Abubakar is the 1999 Constitution, which is still the Constitution till today. It has not been amended. The Supreme Court has said that defection by the President or Vice President, and which will apply to Governor and Deputy Governor, will not be a ground for removal from office. That is clearly settled, and there hasn't been any contrary pronouncement to that effect. Now, with respect to whether the National Assembly should now include defection as a ground, yes, the Supreme Court has acknowledged that it may be immoral, it may be very disconcerting for a person to be elected on one platform and now cross to another. I will agree that the National Assembly can now include it as a ground for removal of the governor or deputy governor, as case may be.
All right, Mr. Ogbole, do you agree with him?
Well, I agree that to the extent that this is a very good avenue as the lawmakers are considering you know, amendments to the Constitution. They can also see what is going on with cases like this. These are some of the issues that can properly be addressed and you know, clearly spelled out and laid to rest. Once it's clear in the Constitution, it makes the task a lot easier for judicial interpretation. And in which case you will not blame the judiciary for going for interpreting it the way they have interpreted. Now,
if I can ask you just a quick one,
my brother said.
Okay.
My brother said. Okay.
Go ahead very quickly because we are closing. Go ahead, Mr. Ogbole. We are closing.
Oh, okay. In relation to the analogy you tried to to bring up between the Atiku case. A clear answer to it would be the Faleke case. Because on the one hand, he supports Atiku case, but he is also one of the lawyers who did the Faleke case. So what does he say about that? Okay. In the Faleke case, which came way after Atiku, the position of the law was clear that it was a party that had the votes, which was also in tandem with the position of the law in Amechi's case. And then it goes back again to section 221 of the Constitution.
My apologies, we've completely run out of time. But you know, we have to adjourn this case. We have to adjourn this sitting. We're an intervention organization. Okay, we have to thank you very much for being a part of this conversation, gentlemen. Paul Ogbele and Kunle Adegoke, both senior advocates of Nigeria. Thank you so much for your time and your perspectives this morning.
Thank you very much.
Okay. Well, we take on another issue right after now. Stay with us.
Well, yesterday was International Women's Day, and the women weren't just sitting down and just celebrating. No, they were at the gate of the National Assembly, and in the different states, the wives of governors led women to protest the rejection of bills which are supposed to ensure that both genders are recognized and given equal footing in Nigeria's constitution. Well, yesterday, the House of Reps, that's the House of Representatives, in a surprise move, one would say, decided to rescind its decision on 3 of the bills. You already saw them there: affirmative action, talk about indigenization, and also allowing women who marry foreign nationals to be able, for their foreign husbands to be able to enjoy this citizenship of Nigeria. So they did that. They said they're going to reconsider. So it's not exactly uhuru yet. But let us ask if this is a step forward To our guests here this morning, we have with us Honorable Benjamin Kalu, who is the Chairman, House Committee on Media and Public Affairs. Honorable, you're welcome to Sunrise Daily this morning.
Thank you very much for having me.
And we also have Madam Ene Obi, who is the convener, Nigeria Civil Society Situation Room. You're welcome,
Country Director, ActionAid.
Yes, we mustn't forget that part.
Yeah, they are the ones paying me.
Good morning, ma'am, and welcome.
Thank you so much for having me.
It's been a busy last 2 days, last couple of days since the House of Reps, generally the National Assembly rejected those bills in the Constitution Amendment, which is currently ongoing. Yeah. What would you say the reception of the protest has been so far?
I think it's been wonderful. You know, it's been great. You know, since the rejection, we've been at the gates of the National Assembly. Very responsible, you know, women, you know, we're dedicated to that. And we are happy that we have been at the gates of National Assembly. We are aware that there are several gates. We didn't block all the gates. We just went to one of the gates, and we are able to at least stay and protest against the bills. They threw them out of the window. So we are happy about the development that the National Assembly, we wanted to see the leadership. For the first day we were there, we wanted to see Right Honorable Femi Gbajabiamila, you know, who is a Speaker, House of Representatives, and we wanted to see the Senate President. None of them came out. They sent messages. They wanted, you know, maybe some of them wanted discussions, but we did not move anywhere. They still send the women, you know, members of the parliament. A number of them came at different times. We've had VCs from the, you know, some of the first ladies. You know, they were, on each day we're having some visitors. And yesterday was the celebration of International Women's Day. Because this thing is happened, it started on the 1st of March, which is a month for women. And so we found, you know, it was like a big slap for us, you know, and we feel that Nigerian women are on trial, and that's why we are still calling on all women, wherever you are, you know, that the state of the National Assembly gate is where you need to be from all walks of life. Mm-hmm. If you cannot come, bring water and let people drink, because the sun is so, it's really humid out there, People drink almost 4 bottles of water, but we make sure that people keep rehydrating. Medical women, you know, doctors, Medical Association of Women Doctors, or is it Association of Women Medical Doctors? They are there. They have their ambulance, you know, and they are working with us. International Federation of Women Lawyers. They are also there. All categories of women. Professionals are there. Market women are there, and so we have women from the rural areas. And these are women who know the issues. We are not just mobilizing because we want people to be at the gate. And so it's been wonderful. Different sectors of professional women. Some of them will say, I take water. This one say, I take this one. And we have been okay. Mm. So we're happy that certain things are coming up. But you see, we are not looking for favors. Women are 50% of the population.
At the minimum?
At the minimum, yeah. You know, women are there. And so the huge population, the voting population, women are huge. And they are not at the decision table. We have a lot of crises in Nigeria today. We have Chibok girls that are still, you know, many of them, more than 100, are still behind bars. Can you be a parent to any of these ones? So we have a lot of issues. When, you know, some of the men will run from home, they abandon the women, but you have your children, you have to raise them. We have so many single women. We are not asking for respect for women because they are married or unmarried, whoever they are, they have a life to care for. Mm-hmm. And they have done excellent work. You know, a lot of them have done so well. And we are saying, enable the environment where we can be at the table together. We are the ones who bear the children. Mm. I have boys, I have girls. And those are the population that are coming to Nigeria when all of us have vacated. And so, and then the national anthem says the labors of our heroes past shall not be in vain. And I keep emphasizing, the likes of Gambo Sawaba is all the way from the north. Fumilayo Ransom Kuti is from the southwest. Margaret Ekpo is from the south-south. And they played a role, even as Standard 6, you know, graduates. They played a role in the Nigerian independence. And here we are again, you know, on trial. We have millions who are professionals now. Millions of doctors, professors, PhD holders, engineers, and so on and so forth. So we worry about the future of our children. There's a lot of unemployment right now. When children they can't even ask they can hardly ask fathers for pocket money so they come back to you. And we are flustered by a lot of things, which want women to be part of decision making. Because I always say that the quality of a decision depends on who is in the boardroom. How can you step in about 15 houses of assembly, not one woman? Men are chairs of a women committee. How does that work?
It's really, there are huge questions as to how we got here, because it wasn't always like this. And even the National Assembly, from 1999 to where we currently are, this is 2022, the figures of women in the National Assembly, if we're just to take that alone, has continued to decline. So there are huge questions as to what is happening to women in terms of political participation. In the private sector, it would seem that they're making a lot more headway, but it's not, it's not corresponding in the political sector. So there are questions as to what is really hindering women from participating. Well, Honorable Kanu, let me come to you. First, before I ask you, as spokesperson of the House, what made the House take this decision? Let me ask how you voted, when the bills were first considered. I know the Speaker of the House has said he's going to release that. I do not know if he was just saying it, but we are going to hold him to his promise, because he did say he was going to release how members voted. Are you willing to tell us how you voted?
Well, you see, I speak for... Thank you very much for inviting me first. And I want to congratulate the women once again for the International Women's Day. And also want to celebrate the women for what you are doing.
Thank you.
At the moment, your agitation, your protest has been well coordinated. I see a lot of matured management of that activity, and I really commend your effort. I see prominent individuals with capacity standing there and raising their voices, and we, as National Assembly, we commend you for pushing for what you really want, which is supposed to create the balance that all of us are yearning for. I'm not allowed, as a spokesperson of the House, to speak about myself and my activities, but I'm sure
that, the Speaker of the House of Representatives, I still remember him saying that in this instance, it is one man, one vote. And there were very, very strong, let's say, rules guiding how the House conducted itself on that day. We saw how he kept on insisting that members had to sit in their chairs in their rightful places, because he needed to know how members were voting. And at some point he said everybody's going to be accountable. So in this instance, I would imagine that there will be exceptions to the rules if you're not allowed to speak for yourself. But in this instance, I imagine that there will be an exception, because this is about how men and how generally, because I think almost 97% of the House is made up of men. Well, so we need to know, just how even the person who speaks for the House voted.
Yeah, the report is going to be out, like the Speaker promised. He usually keeps his promise. And also the report is also accessible to the public based on freedom of information. You approach the clerk of the National Assembly or the clerk of the House of Representatives, it will be made available to you even before the Speaker decides to make it public. But I must say that I voted for one of those clauses. And the one that passed through the House, that has to do with increasing the number of women in the ministerial positions and also at the state executive cabinet. The other ones were dusty at the time it was looked at, and that was why we went back, to look at the message conveyed by those provisions, and understood it better and started lobbying the members of the House on the need to retrace our steps. And I was in the forefront with the leadership to make sure that we have members have a second look, because truth be said, Section 26 that the women wanted amended, which has to do with
expansion of the qualifications on citizenship is not a threat to anybody, because most of our children overseas are enjoying that when they marry foreign partners. So who is being hurt if the ladies bring in their spouses and they qualify for citizenship? There is nothing wrong with that. It is their entitlement. And we said that we need to, and a wise man do change his mind. If you find out that the direction you are headed, you made a mistake, you have to retrace your step and review things. And this parliament, I must say, is not on ego trip. I've always said that we are sensitive to the yearning of the people. So when you have a population of 101.67 million women, as against your 104.47 million men, and you say you represent the people of Nigeria, women, part of this population, and their tears should touch us. So the next one that they wanted to look at is section 223, which has to do with the affirmative action. And we're talking about 35% in political administration. We are saying if you have about 28 members of the executive of a political party, and then you're having about 7 or 8 women there, what hurt is it going to cost? So that was another reason why we pulled back. And then indigenship, which that we are trying to break barriers as we look forward to becoming a global community. All these, demarcations. We are somebody who is not from Abia State, who has lived in Abia State, qualified to become a chief judge, and because she's a woman and married to a Abia State indigent, she'll be told you cannot be a chief judge. That is discriminatory. That is not supposed to be. And we looked at that and said, yeah, this will affect even our own daughters, because we have children, and who is going to be hurt if you get married and you stay there, be of good behavior 5 years and become an indigent, and you are open to the privileges enjoyed by the indigenous? What hurt will it make, do to nation building? And that was why we said, no, these deprivations are not supposed to be. It will further, lengthen the scope between women and their participation in governance. And as we are striving to bring them closer, because that is the expectation of sustainable development goal. And that is the expectation of participating in the Beijing conference that gave 30% affirmative action to women, though our own national agenda policy has placed it at 35%. And if you look at the average, the global average on this is about 22%. The African average is 23.6%. The West African average is at 16.7%.
And Nigeria is the one dragging it down.
Yeah. So we are trying to see how we come up the ladder by making sure that, because what is happening now, let's take for example, in the current appointment of women in the Executive Council, you have about 6.7% there. It's not what it ought to be. So we are saying some of these things we can gradually look into them. It's not just what it
ought to be. It's a decline from what it used to be. So, I mean, their question, we're doing better. The question is, why is it so difficult to maintain it and to even do far much more? So it's a good thing that this has been reconsidered. As you said, a wise man changes his mind.
Yes.
So the question for me was that, is it that these bills were not understood initially, or were there external factors that pressured the men from considering the wordings of the bill? What went wrong? Let me put it that way.
You see, I've always maintained, but I was having a chat with the lady, Mrs. Enobi, before I walked in here, and I said, lobbying is part of democracy. So when you hear lobbying, it is nothing bad. It's part of pushing your agenda to receive a greater buy-in by people who are supposed to make the decision on that particular issue. And now when you draw up your stakeholders administration list with regards to a particular agenda, there are certain people that must appear there. You don't ignore the constituents that have elected the people who came to National Assembly. And these constituents, through stakeholders meeting with their representative, roundtable conferences, town hall meeting, communicate their desire on a particular issue that is before the National Assembly. Now, from our
patriarchal system that we are coming out from, our traditional belief, even our religion, call it Christian religion, call it Islamic religion, projected men to the point of prominence, and women capacity is being looked at in a way that the women are beginning to complain currently. And if you ignore the existence of these as part of our society, you make a mistake. So you need to go the extra mile of making sure that if I have an emir in my place that has a controlling voice in what I do in National Assembly and played a role in my coming to National Assembly, there should be a means of reaching out to him, for him to have a buy-in on there is no threat in women becoming indigenous of this community. Let's get it go. The emir will reach out to me and say, Benjamin, on this issue, we are together with you, go for it, positive. It gives you confidence. You're governor. These are the stakeholders that should appear on the stakeholders administration list. And the same thing applies to my traditional rulers. It applies to faith-based organizations, applies to political business people. There are controlling forces that made your election possible. And you are not representing yourself. You are representing the people.
So you fear that those controlling forces haven't quite given the support which the lawmakers needed, or did not affirm the decision for the lawmakers to, give the go-ahead, give a yes to the vote which was placed before them?
I feel that the vote of the parliament is not a vote of the parliamentarian, but a vote of the constituency. And therefore, literatures, advocacy materials, marketing tools of this agenda should not only be concentrated at the parliament. It should reach out to all these ones so that we have a holistic buy-in. So that not when I finish voting and I go back to my constituency and they'll ask for my head. So, and we should not play down that religion and culture plays a role in our society. We will get to the point where, these threats will be reduced. People will begin to see the benefit of what the women are asking for. We are not yet there. We are advancing. Remember the PIB. When the PIB came, it took a long time. People believed it wasn't going to be done. Today, it has become a PIA. And so with other laws, like the electoral reform, we have had a lot of debates here on the need to have electoral reform. And it has gone back and forward. But at the end of the day, it has been gotten. Why? Because the communications have been done properly. And this is not undermining the effort of the women. To be honest, work has been going on since 1999, but they need to do more to increase the buy-in.
Is it just about the women? Because there are big questions. I was speaking last week to a governor, and I was asking whether this was a function of women. Because if you look at a lot of, men don't exist in isolation. When I go home now, I'm not going to go to a separate house from that of my husband.
Yes.
I'm married. I'm going to live with my husband. If we have children, we send all of them to school, boy and male and female. So have our lawmakers. A lot of them. Some of them even have their partners in the National Assembly. Some of them have them heading parastatals in other places. So they understand the importance of education, and in many instances they see them as equal. So is it not right that they begin to push, that they begin to enlighten their own constituents, if they're not yet enlightened, on the benefits of this from what they have seen? Or do they themselves feel threatened by it?
No, this is why we have gotten to where we are, 4/5 at the moment, between the last voting and now. And it's not easy to rescind the decision on the constitutional review. We got to where we are today because of what you just said. We engaged, the members of the parliament, engaged the constituents to convince them. The members of parliament went in to lobby on behalf of the women.
You know why this is a bit odd? This is a bit odd because Honorable Onyejocha, I still remember the bill which she sponsored, and she expressed a bit of shock because she said, there were over 100 lawmakers sponsoring that bill. She had confidence because the speaker was co-sponsoring the bill with her, and as a result, his fellow men lined up and, they were all co-sponsoring the bill. Yet, when it came to the vote, it was saying that nobody understood what it was about in the first instance, or perhaps they didn't realize that what they were co-sponsoring and supporting had come to the vote. So there are questions as to what exactly, was it just an exercise in, let us just say yeah or nay, depending on how we feel, on the speaker's voice?
You're still not paying attention to this very all-important factor of our society. and the law is made for the society. And there are people who play major roles in this society, beyond the parliamentarians. I don't want to present it for Nigerians to see parliamentarians as, okay, you have the powers to do this, you go and do it. No parliamentarian has a power that is not delegated to him by his constituents. If you are doing that, you are presenting yourself.
Are you saying
you are not representing yourself.
You just said that 50% of your constituents are women.
Are women.
Exactly.
But what happens to the other percentage? And how many of that 50% of our women are occupy the space of the stakeholders administration list? You know, because of the realities in our society, because of our historical background, it's a gradual process we are advancing towards becoming what we ought to be, you know, among the Committee of Nations. And so that when we go for peer review, you know, some of this indicator that is used in measuring how far we have gone with sustainable development goals and all the rest of them, that will come up. It's a desire for some of us who are in government to make sure that we come up from where we are to where we ought to be, so that we'll be looked at favorably when we meet with our colleagues outside the shores of Nigeria. But you see, our society plays a role, and we will keep working until there is a buy-in. The Parliament is not the enemies of the women, no. The Parliament is in partnership with the women to make sure that their inclusion in governance is increased. We are not happy with the level it is at the moment, but we'll keep pushing for a greater buy-in so that it will be done.
Well, my male colleagues are not leaving me alone on this conversation. Gentlemen, you have the floor.
Absolutely, Mokwe. Thank you very much. Honorable, there's still a lot of hurdles to cross on this one, and it's understandable that a lot of attention is being focused on you because essentially the National Assembly has the powers. You've tried to give some insight, but let me come to Madam Obi first before I take this back to the Honorable. So the Honorable has said that, you know what, whatever powers they have has been delegated to them. This is for Madam Obi, by the way. So he says whatever powers they have has been delegated to them by their constituencies. So do you think that the women that make up the 50% block of our population understand, you know, what is at stake here and is supported? Because by inference, it will be 50% at least of his constituency as well. And if 50% say, this is what we want, then it's only fair. I imagine that almost 30% of the men will follow suit because, I mean, I know men who are, what do you call it, he for she. So let me just ask, do you have an authority that, you know, the women in Nigeria, 50% that make up the population, are in support of this?
I first want to commend those who voted for the bill. You know, I want to commend the leadership of the House of Representatives. We're still waiting for the Senate.
No, I don't think they voted on it just yet.
Voted. No, they vote, the earlier vote.
Oh, the earlier one, okay.
The majority carried the day.
Right.
You know, we want to appreciate them, and
thank you.
We are happy that, you know, they went back yesterday, listening to us and for us staying at the gate, you know, into the protest. The 50% of the population, women are the heaviest voters. And that is why we are asking for the list, because we also want to look for the list so that those 50% can engage them at the constitution, you know, at the constituent levels. And it is important to see how we are voting, you know, because these are realities here. I'm married, I'm from Benue, I'm married to somebody from Anambra State. What it means is that I cannot, all this while, to go into election is a different thing entirely, you know, and so many people. So what Honorable is saying is, yes, I don't want this to happen to my daughters, but it happened to your mom. Those who were your mothers, it happened to them. And this is the reality, and that's why we say we are on trial. And it is important, going forward, we are going to 2023, the lives of our sister Salome was burnt down, broad daylight, a woman inside her room. A mob went and burnt her down. Gender-based violence on elections. And so when you have a reduction on the representation, a lot of women that you have mobilized, some of them fear for their lives. And so there are so many things that negate, despite the issues of patriarchy, you know, the issues of culture, the issues of religion, both religion, you know, that is major in Nigeria, subjugates women. And the culture also subjugates women. But in a lot of ways, there is an appreciation. If you go into farming, you know, women farmers, you know, actually currently holds the Secretariat of Small-Scale Holder Women Farmers. 75% of the farmers, you know, are women. And so their contribution to the economy is not even recorded or is not even seen. They are not to be seen because men really go into where you have massive cash, you know, produce and things like that. And so today we are calling for the names because we want to engage them. All those who vote against, let's just have their names. If they don't understand, we will help them to understand what we're talking about. But I'm happy that it's not just, you know, when you have a block of people, we have to realize that not all of them are anti the kind of perception that we're talking about. Some people are fighting very hard for this bill to go through. If we have 6.7% of women representation in parliament, that's a male parliament. It's a male parliament. The decisions, you know, we are at the last 5 of, you know, at the bottom list of maternal mortality in the world. And that means that any woman who is pregnant is on a maternity death road. We are losing so many of our women in the villages, in so many places. There is no way that men will tell you what it is to feel, to be in labor ward. And when women have obstruction, you know, our medical doctors were on stage yesterday, you know, at the National Assembly, you know, gate there, telling us about the confusion they have with women at childbirth. And so we are saying, if women are in charge of the production of the human capital of this country, yes, we have the men. Nobody is saying that we're against the men because we need them. Oh, my husband is there. My children, my sons are there. I love them so much. My grandpa, my dad, and everybody. We are not saying delete. You can't delete our children now. So we are in it together. We want our daughters and our sons to be on the decision table together. That's why they struggle. That's why a woman will tie her wrapper, sell all her gold to make sure that both the boys and the girls under her, the humans that she's protecting, they are protected and they have quality education for their future to be bright. Women, so if we have a situation where you have about 100 million Nigerians below the poverty line, what that means is so many of our sisters are crying every day to have food to put on the table for their children. The humans that is under them, they need to cater for them. And so the belief is, you know, in all of it is that we need the progress of this country. And for the Sustainable Development Goals, so many goals are on issues of education, issues of poverty eradication, and so on and so forth. How do you do it when the decision that is taken is upside down like this? When the population is like this? When you are cheating yourself because you are not doing the women any favor, but making sure you have quality.
So the question for me right now is, what is the guarantee that this is going to produce any different results? Yes, they have decided that they're going to rescind their decision on at least 3 or 4 of the bills, which is a good step, but it's still going to be put to vote again. How do we know?
We are still at the gate. Yeah. We are still at the gate right now. We are waiting for the Senate. You know, we want the House of Representatives to up their game. They have done well. We commend you, commend your team. We still ask for the list. And we wait for the Senate to do their own bit. I'm going back to the gate now. You know, all colleagues are at the gate, and we'll continue to occupy the National Assembly. We want to see how they are voting. If there is a promise or something that if the Senate goes back and they do the needful, we don't want anybody to come and even talk to us. You know, do the needful, and then you come back. If you are able to do that, and you say in 4 weeks they are going to process it adequately, we wait. We'll come back to the gate.
So, Honorable, the questions are still...
sorry, it's not just coming back to the gate. When we get angry, we'll go inside. You know, and we are now mobilizing very elderly women too. Those who are retired, who know that they need to leave their legacy, to come to the National Assembly. It will not be nice, but we will get there.
Well, you're one chamber of the National Assembly. What has the response been since you took this decision? Have you gotten any feedback from the Senate?
Yeah, thank you very much. Let me also start by saying that I commend the women, the work you're doing. I also commend how you have handled it decently.
We're almost out of time,
Yeah,
Honorable.
on the issue of communication with the Senate, you know, Section 60 and Section 101 of the Constitution allows us to regulate ourselves. And many have argued, is there going to be harmonization? Is there not going to be harmonization? But we are relying, like you heard the speaker say, we are relying on this Section 60 and Section 101 to, you know, regulate our activities, and that includes getting the Senate to see things from the perspective we have seen things. It's not the first time it's happening. Remember, when it comes to electronic transmission, we took a different position and they took a different position. Later on, there was a buy-in from them. And when it came to 3%, 5%, they took a different position. We took a different position. Later on, there was a buy-in. This is another piece of lawmaking. It won't be different from what we have done previously. So we will regulate ourselves and make sure we push it out. But I will advise the women, don't just sit at the gate. Let there be some literatures also sent in to every member of the parliament canvassing these ideas. You know, write to the members of the parliament, members of House of Representatives, write to members of the Senate. Don't just sit at the gate, so that they will look at it and build their conscience towards your own agenda. It is doable, but you need to communicate more positively and more effectively.
Well, we have to thank both of you for coming on the program this morning. Honorable Benjamin Kalu is the Chairman, House Committee on Media and Public Affairs, and NLB is the convener, Nigeria Civil Society Situation Room. Thank you so much for coming on Sunrise Elite this morning. We have feedback from our viewers this morning, and I'll take the first two. Professor Enakena says, for Nigeria to evolve politically and economically, Nigerians must desist from pedantic views about women and capabilities to enhance their total inclusivity. We must look within and patronize or support the ambitions of women with abilities in the polity. And Child 066 says, this Ebonyi judgment is a test case. I hope all legal options will be exhausted. But my question is, what now happens to all the senators and legislators who have decamped without any visible crisis in the national body of their political parties? Big question.
Well, we could keep asking those questions, Marco, but if we allow ourselves to take all of the messages, we'll definitely be no questions to ask tomorrow. But Kingsley, Oshinawa, Festus Akinboyewa, Ngozi Okole, Olagunjo Oladele, we got all of your messages. Thank you so much for being a part of our program this morning. I'm Ayo Makinde. Have a wonderful day, and God bless Nigeria.
I say amen to that. I'm Kayode Okikelu.
And I'm Maokwe Ogun Yusuf. Have a good day.